Saturday or Sunday, depending on which day. All right. Hi guys online, and hi to the few of you in person. Welcome to this workshop. Just for the sake of my own sanity, if you could turn your cameras on, that would be very nice. Look, today is obviously an optional session. Those of you attending online, welcome. Those of you in person, welcome. I'm telling you, I'm going to say this, but because you're here, it doesn't really apply to you, but not doing this session is very, very bad for your team. So this is going to go over procedure, and like I said, in the trials, I'm giving no mercy to teams that don't understand procedure. So I'm going to instruct the judges to be strict about the way that the trial procedure is, guided. Hello. And we're not going to give any, leniency to teams that don't understand procedure. So that's the philosophy. So stick around. Hopefully you understand. And we have like a small little interactive feature at the very end that we can test our theories. So this is fundamentals of American trial procedure. If you're taking litigation right now, somewhat similar, except obviously we're learning about U.S. procedure and not like German procedure or whatever. Okay. All right. I'm going to jump right into the basics. Jurisdiction. There are three reasons that you go to federal court, and it's for federal question, diversity, or supplemental. So federal question is basically any issues that are under federal law and not state law. So constitutional issues, federal law, federal codes, treaties, stuff like that. For some of your cases, like the Qatar Airways case, you're probably more under the diversity jurisdiction, which is cases between citizens of different states or foreign countries. And usually you have to have more than $75,000 in question in order for it to be diversity jurisdiction. That's under 28 U.S.C. 1332. And then there is supplemental, which basically allows federal courts to hear original jurisdiction claims. So basically, even if it was started in a New York court, the federal court can say, or you can petition the federal court saying that this is more of a federal question to be answered. It kind of loops back over to federal jurisdiction. And they can basically take any court claim, even if it's like, some bullshit like my dog, shit on my neighbor's lawn and I'm suing him for it or whatever. I don't know why you'd be suing your neighbor for your dog. But anyway, you can also, the court can claim any of those as federal jurisdiction. That's usually a court decision, but if it's supplemental. And then venue, the only thing that applies here is general venue, 28 U.S.C. 1391. Which basically says a civil case can be filed based on where parties reside or the events occurred. So if parties live in New York, you can file a claim in New York State, obviously, but you can also file it in the District Court of New York, Federal District, which I think most of you, all of you are in New York, right? You're in New York. You're in New York. Mm-hmm. You're in New York? You're in Columbia. Yeah, okay, so you're in DC. But that's because DC covers federal claims, like cross country, stuff like that. Hi.
Sorry.
Yeah, you're good. Come on in.
Thank you.
And yeah, that's what general venue is basically. I highly doubt that any of your claims are going to have this big question, or like, I don't think anybody's going to be challenging jurisdiction or venue, but that's kind of what you'd use if somebody does. So, yeah. All right, so you got the basic process of trial court. Number one, you file the complaint. Today, in theory, that filing will be done, right? This basically initiates the lawsuit, and this is what we call service of process. This is that thing that you see in like TV shows or stuff when they come. Usually it's like a police officer or like a lawyer or something, and they come to your house or whatever, and they hand you a stack of documents, and they say you're being sued. That serves a process. Now we do it a little bit differently in the trial competition. Usually before you even hit mediations, like months before, you would have gotten this claim, and this already would have happened. But we're doing it backwards because that's what we're doing. Then there's an answer or a motion to dismiss. The difference is answer or motion to dismiss. You never answer the question as a defendant and then also ask to dismiss. You don't answer a dismissal request, right? You don't say, yes, we're accepting this lawsuit, but also can you get rid of it? You have to pick which one you want. For most of you, I would say that the best bet is to go for just the answer and not to ask for a dismissal, because we're not going to grant a dismissal. But if you think you have a genuine claim to it, then we'll still rate that and whatever. Then you go to discovery. Again, you've already done this you have a case packet with all of your information in it, has all of your evidence. And that's when you exchange information. You send each other documents. Say, this is what we're going to use in court. These are our witnesses. These are the witness testimonies, and that's kind of what the depositions are, which is what we're going to go into next. And then, of course, you go to trial. And that's when you go to the jury and the judge and whatnot. So, yeah. Also, if you have any questions throughout, you can ask, but I'll answer things at the end.
Are you going to send us the presentation?
Yeah.
Okay.
Rules of Civ Pro. Okay, these are the two things this is what I would recommend you using for preparation in terms of procedure. Look at your Civ Pros and your Title 28. The Federal Rules of Civil Procedure is basically like how you introduce evidence, stuff like that. You also have a copy of that document, kind of modified for our competition, on the website, elsaie.org/share. And then Title 28 is actually more about judicial procedure, and this is what you would use in an appeal if you're challenging the judge's verdict. So you would use Title 28 for that. You would say, according to this title, the judge did not give us the correct answer because this and this. Depositions. All right. This is Civil Procedure 30 and 31. This is basically your affidavits, those witness statements that you see. It's a statement of whoever. Basically, an affidavit or a deposition, usually they're way longer. They're like 20, 30 pages long. Obviously, we've shortened them, so that way this trial doesn't take like 8 hours. But this is basically to obtain testimony from the witnesses or parties that are going to testify under oath. And you use it basically as a lawyer, is used for discovery to see what the other side is going to probably talk about. And that's how you kind of prep your own witnesses. And you obviously have the depositions of your own witnesses, so you know what their story is. And you can question, prepare your questions and responses. There are some small rules here, but it doesn't really matter because the depositions have already been taken. But usually, courts say that your deposition can only be 7 hours long. And the way it works is you go into a room with a camera, they turn on the camera, and no matter what, once that 7 hours is hit, you're done. Adam.
Hi, sorry. One of my teammates is trying to join online, but.
Oh, all right.
Thanks.
Yeah. Okay. All right. There are some motions that are usually done right at the beginning of trial or like right before trial. And these three are the ones that are the most relevant for us. There's motion to dismiss. You're basically saying the other party has no. This is usually done by the defendant. I don't really know why a plaintiff would want to dismiss the case, but the defendant would usually say, "This we want to dismiss because the plaintiff has no facts that are even worthy of bringing this to trial." So usually, you have to have the plaintiff has to really be like really screwing up in order for you to claim a motion to dismiss, because all you need to bring something to trial is like a probability of it even being a claim, right? So even if the evidence is bad, that doesn't necessarily mean that you can dismiss it, right? It just has to, the evidence has to be non-existent, basically, or just super not really related to anything. Yeah, anyway. You can basically dismiss for a couple things: lack of jurisdiction, improper venue, insufficient service, which you can't do in this trial, but that basically means that, when that guy comes and hands you a stack of documents, if they didn't come and hand you the stack of documents, or they I don't know, put them into a paper airplane and like throw it into your window or something, like that doesn't count. You have to like actually be handed the documents. Now sometimes the people will like, if you've ever seen the show, I doubt any of you have seen it unless you're from the US, but there's a show called Cops in the United States. It's the longest running television program in the United States. And it basically is they follow this guy, or they follow like these police officers around with a camera. And that's all they do. They just follow them around. There's no like cuts or anything. It's just a TV show where they follow the police officer around. And a lot of times police officers have to serve processes, and they'll go to people's houses, and the people will like run away from the police officers so they don't get handed the documents, because then you can ask for improper service. But as long as they like touch the document with their hands, it counts as service. So you'll see the cops like grab their hands and like slap the document out of their hands and then throw it into their like porch, and then like that's service. You know what I mean? Anyway, it has nothing to do with this trial, but I think that's funny. So yeah. You would, if you do want to try to go through a motion to dismiss, you do it like right at the beginning of trial. The judge will say, are there any pretrial motions? You'd say, yes, Your Honor, we'd like to motion to dismiss the case. And we'll hear it, you'll argue it. While it's very unlikely that we'll dismiss the case, if you do think you have a good argument, we'll definitely score you higher if you make a compelling argument for dismissal. Okay. Then there's summary judgment. We actually are entertaining this. You can ask for this at any point before or during the trial. This is basically saying, a lot of times the defendant will ask for this after the plaintiffs rest their case. So the plaintiffs will say, okay, we're done. Like those are our witnesses. This is our evidence. Now it's time for the defense. And if the defense thinks that the plaintiffs have not really done anything at all to like add anything to the case, they can say, Judge, we'd ask for a summary judgment, which is basically saying, I want you to make a decision right now. We don't even want to present our case. Like this team just like these people suck so bad that they like we just go ahead. Like we think that you're going to rule in our favor, and the judge will either deny or grant a summary judgment. And basically, the judge will look at the current evidence or the current facts and say, "Here we go. Like this is my decision." Usually, you have to get both parties to agree on it if it's before the trial. Like you could say, like, we want a summary judgment right now. They send a claim, you send a response, and then both parties can submit a petition saying, can you just read the two documents and make a decision? Sometimes that's granted if you can get both parties to agree, but usually the judge will say, no, because the other party wants to go to trial. It's their right to go to trial, right? So, but during the trial, it's up to the judge. If the plaintiff or the defendant says, we want a summary judgment, then yeah. And then there's motion for a protective order. You can do this to do a lot of things. You can limit certain evidence. You can limit discovery. You can sequester witnesses, sequester evidence. You can exclude evidence. Protective order covers a lot of things. Like the classic protective order is what you would call like a restraining order, but we're not in a criminal trial, so it doesn't really apply. But you can also say like we want a protective order against, this company because it's also called an injunction. I don't know how many of you take litigation right now, but an injunction basically says like, if you're suing like an oil company for drilling in your backyard and you sue them, you can ask the court, we want a protective order or an injunction to make them stop drilling until the end of the trial. And then if it rules in their favor, then they can drill again. But for now, we want them to stop drilling. That's basically what you do. Do the same for anything. For example, the defendants in the Qatar Airways case, or the plaintiffs in the Qatar Airways case, Qatar Airways, can file for an injunction basically saying we want to suspend the travel ban until the end of the trial or something like that. And then you would respond and say, well, we shouldn't do that because this is.
Okay, so the other side has to respond and not the judge.
Well, so you would petition for this at the beginning of the trial. The judge will say, are there any motions? They would get up, say, we want to suspend this thing. The judge would say, is there a response? You'd kind of argue for like a few minutes, and then the judge would say, all right, I'm granting or denying this motion. This is big for like when trials are supposed to last like years or like long time. Obviously, these trials last 2 hours, but when you have like a huge major trial that's going to go on forever, because these injunctions last not just through the trial, but through the entire appeals process as well. So if somebody files an appeal, the injunction lasts through the appeal, unless of course the appeals judge reverses the injunction, but that's the whole, we're not waiting for that. Okay. All right. In trial, you start with opening statements. You start, plaintiff opens with opening statements, and then the defendants are allowed to choose whether they want to do their opening statement directly after the plaintiff, or they can wait until after the plaintiff has introduced all of their witnesses, and then they can do their opening statement. It's up to the defendant. And basically, in an opening statement, you're not like arguing your case. You're outlining the basic facts and legal issues, and you are basically like offering this like viewpoint to the jury or the judge of like how they should like view the evidence. So if you have, I don't know, a document from this guy saying that he is the one that broke the window, instead of saying, we're going to prove that this guy broke the window, you would say, you know, we have a document that suggests that this person broke the window, and what we want you to do with this document is to consider the fact that he was drunk when he wrote this or something. You know, you're trying to like frame this way of presenting evidence. You also want to introduce yourself and your client in the case, and basically just be like, this is our theory. This is what we think is the main issue. And this depends a little bit on whether you're doing a jury trial or a bench trial. Most of you are doing jury. Some of you, I think a couple of you are doing bench. In a bench trial, you're talking to a legal expert, you're talking to a judge. So in a bench trial, your theory can be like, your legal, like, in this case, they said this, and in this case, they said this. In a jury trial, you're talking to a bunch of like plumbers and shit. So like, you need to like be more like, I don't know, you're like telling a story. You're like, this is, you know, he got up and he went to the store and he crashed his car. And how would you feel if you crashed your car into the, you know, side of like, you know, Mercadona or something? And, you know, you phrase it like that. And then you want to mention like significant facts and witnesses and evidence. So like, you want to be like, well, you know, Timmy was the store clerk for the day and he saw the whole thing happen, and you're about to hear about that. A couple things you don't want to do is be really fucking long. It's really annoying. Like the judge hates it, the jury hates it. Blah 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 blah. We get it. Like, you want to be concise. You want to be straight up. This is what we're gonna do. This is how it is. Period. And you also want to be like confident about your client. I know it sounds like obvious. Like of course you believe in your client, but like too many people do opening statements and they're like, and they're gonna claim this. And while that sounds pretty convincing, you don't want to even like acknowledge the other, like they don't even exist, right? You want to like, it's all about your client, because the second the jury starts hearing, oh, they're going to bring up this, then they start cranking in their brain like, what if they did do that? You know, so I don't know. I would just not mention it. Same goes for both sides. Opening statements are like the least relevant part of the trial. Closing statements, on the other hand, I would consider the most relevant part of the trial. So. All right, then we have direct examination. I hope you all know the difference between direct and cross-examination. If you don't, please make yourself heard right now. Okay, yes. Need it? Okay. Direct examination. You have two parties in the trial. You have the plaintiff and the defendant. The plaintiff calls witnesses and the defendant calls witnesses. If you are the plaintiff and you call witnesses and you're interviewing your own witnesses on the stand, you are doing a direct examination. If you're examining or questioning the other witnesses, you're doing a cross-examination. There are rules for both. Direct examination is more formal than cross-examination. In direct, you introduce facts, and you're basically introducing these facts to establish a case. So, how can I? Last year, we had a case called the Von Schnapp's case, and it was a murder trial. Okay? And there was, give me a witness from the Von Schnapp's case.
For direct.
Yeah.
Any
Just give me a witness.
Genevieve.
Yeah, Genevieve. So the defendant, right? Yeah. So if you are the defense team, you would call a defendant, and that would be a direct examination because it's your client that you're asking questions to, right? Through this, you are giving evidence in your case packet. You don't have to do all of it, and in fact, you really should not do all of the evidence. You only show the things that make your witness look good, and you only do things that the witness would know about. You can't introduce evidence that the witness doesn't know exists, right? So if the witness wrote an email that makes her look good, she wrote an email that makes her sound like she's not at the scene of the murder, then you would present the email. You say, can you tell me what this is? And I say, well, that's an email I wrote in May of 2019. Oh, interesting. Okay. So this email that you wrote, why did you write it? Oh, I wrote it because I, was trying to get a meeting set up for that day. Oh, interesting. What kind of meeting? And you kind of like lay the facts, and then you say, you ask the big question, whatever the question is about that document. You say, I don't know, so this email was written at 2:52 p.m. and the murder happened at 2:51 p.m. So you're saying you're writing an email while you were murdering somebody? I don't think so, And then you say, or maybe right before, depending on the situation, you would say, Your Honor, I'd like to admit document reference 47 as an exhibit, and then it gets admitted into evidence. Remember, you don't admit the evidence, it doesn't go into the record. If you don't admit evidence, and it doesn't get put into the record, then the other side can request summary judgment, and the judge is only going to consider what's in the record. So if you never admit any evidence, you don't have evidence, and thus you lose. This is what laying foundation means. You have to lay foundation. You can't just be like, I have a document here. Can I have it in the record? The judge, or usually the other side will say objection, lack of foundation, and then that would be denied, like your evidence would be denied. You have to lay foundation on evidence. No, I'm not.
For the sake of this competition, are we not considering that everything that's in the discovery already is admitted into evidence, or?
No, because I intentionally put about 2 to 3 irrelevant documents into each case packet on purpose. You have to lay foundation. You have to admit it. The only things that are automatically admitted, the only things that are considered part of the record are the affidavits. The statements of the witnesses are already admitted into evidence.
Okay.
Okay. But we are not allowed to bring any new evidences, like
Correct.
besides of all the paper we have.
It has to be the documents. that are
Okay,
there.
that's what I was wondering.
Yes.
Okay.
But I can, and I'll make this clear right now. You can bring external rules or papers, or for example, last year we had, it had something to do with a gun, right? And people went on and found like the details of ballistic whatever from the FBI, but it wasn't part of the case packet. While you can't admit that into evidence, you can mention it in your closing statement. You can say, according to the FBI website, it doesn't mean that it gets put into evidence, but you can mention it.
Only in the closing statement.
Correct. The closing statement is basically your free pass to say whatever you want. You can literally say anything almost in a closing statement. Yes.
Can we still ask witnesses about the outside documents without putting them into evidence?
You can, but you're treading in thin water if you ask witnesses about things that if you keep asking them questions about, you could say, are you familiar with Federal Standard 1.2.3? But if they say no,
Yeah.
or I don't know,
Especially for-
because you can't give them the document because it's not in evidence. So if they say, I'm not really familiar with that, or I don't know that off the top of my head, then
Mostly for direct note.
yeah, you would use it for direct. You would prep your witness, say,
Yeah.
make sure you remember this, and then
Yeah.
you
You
would.
can give and say, I know this.
If he says, I know this, and he can say it off the top of his head, then he can
Without
do it.
giving-
But you can never give him the document unless it's entered into evidence.
But also, for example, I don't know if we would have an agent sitting there and it's a witness, and we ask, okay, you're since then an agent, blah 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 blah. And if you ever had a case like this, how would you what's your procedure? This procedure is not written in our papers, but it's an official procedure normally of the FBI or whatever. Is he allowed, because normally he's an FBI agent and has to know it?
If he's entered as an expert,
Yeah.
only if he's an expert, can he testify to his personal opinion on procedure.
At least we can ask.
He can, if he's an expert.
Okay.
That's the other exception. Is you can reference a lot more outside material if you enter them in as an expert. Okay? And we'll talk about that in a couple slides. Then you have cross-examination. That's when you're questioning the other side's witnesses. So let's talk about leading questions for a second, because this always gets people. And the worst thing ever, and I feel bad for the teams that are not here right now, but the worst thing ever are the first-year teams who start looping in on leading questions on direct examination, and it's objection, sustained, objection, sustained, objection, sustained. And it's just like boom, 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 all the way until the judge is just like, we're impeaching your witness, your case, like, you're fucked. Like, yeah. And so please, 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 please take note on what a leading question is. I'm going to write things on the board for a second. A leading question is a question that suggests an answer. You went to the store that day, right? That's a leading question. You can ask leading questions on cross when you're asking other people's witnesses. You're allowed to use leading questions. When you're asking your own witnesses, you may not use leading questions. So anything that ends in right or correct or isn't it true that or something like that, things that are like kind of bumping people to answer a certain way, that's a leading question. And you can object to that as counsel if the other team does it. And it's very effective. It doesn't do a lot for you, like substantially, but it makes them look really bad if they keep doing it and you keep objecting. Objection, leading, sustaining. And the jury is just like, is this attorney stupid or something? Like, why do they keep doing this? You know what I mean? So, hello. So please, please, please understand leading questions. Now on cross, they're very effective. And the reason that you're allowed to ask leading questions on cross is because these witnesses are against you and they're intentionally trying to hurt your case, obviously, because they've been prepped by the other side. So you kind of have to walk them through everything. You have to say, is it true you were holding a knife, right? Yes. And if they say no, then you can continue to be like, oh, really? Because whatever. Yeah. What you're doing in cross-examination, you're trying to challenge credibility. That's the number one thing. You want to make them look like they don't actually know what they're talking about, especially if they're an expert. If they're an expert, you start asking them questions about, oh, well, how many milligrams? Make sure it's in the case packet, obviously. Like, we know that they're not real doctors, right? You can't be like, what's the average blood type of a, child between the age of 8 and 12? Like, that's annoying. And the judge will get pissed off and that's what we call extrapolation, and that's an objection, and we'll talk about that in a second. Additionally, you want to talk about testimony given during direct examination. Lots of times, if it's my client, I'm the plaintiff, for example, and the police officer walked onto the crime scene and picked up, and was looking at the knife, but then picked it up and rubbed it on his arm and licked it or something. I, as the police officer's representative, am going to say, so you saw the knife, right? And I'm going to stop asking questions there. Because I'm not going to mention that he licked the knife and rubbed it all over his, fingers and stuff. As the defense, if I know this, on cross, this is when I say, okay, so you did see the knife, but you licked it, right? And then he has to say yes, because he's under oath. And then if he says yes, and the whole jury goes, oh, Davey, how could you do that? That's so weird. And that's what you would do, right? So you want to elaborate, because a lot of times the other team that's direct examining is only doing some partial truths. But then also you don't really want to bring up things that, you might have a legal argument that disproves a theory, right? But if they don't bring up that theory at all, why would you bring it up, right? This especially goes for the defense. If the plaintiffs, the people going against you, the people bringing the claim, don't mention that, he even saw the knife in the first place, why would you bring up that he licked it? I would just say at the end, during closing statements, and we don't even know if he actually saw the knife. You know what I mean? That's what you don't want to give them anything, right? Use questions that suggest an answer or contain the information that you're looking to establish. This is the leading question thing. In those barrels, there were 200 pounds of, goat fur, right? And then they would say, yes. You don't want to say what were in those barrels because they, if the whole question was whether or not he stole goat fur, he could be like, oh, there was some fuzzy stuff. And so you want to be as specific as possible. Can't do that on direct, though. So, interactive section right now. How would you ask during direct examination if there was a barrel containing 200 pounds of goat fur? How'd you do that? Somebody? Nobody? Anybody online?
Like, what was the material that was inside the barrel?
Objection. Still leading. If you're saying what was the material inside the barrel, you're still suggesting an answer.
What was inside the barrel?
No.
You see a barrel? Can you confirm whether or not there was material?
That would probably go, as long as you've established that there's a barrel already. Yeah.
Okay, so you would start with.
So you would say, what did you see when you walked into the warehouse? I saw a barrel. Oh, can you confirm? Did you open the barrel? No. Can you confirm whether? But if you say, like, did you open the barrel? It's fine. But if you said you opened the barrel, right? Can't suggest any answer at all on direct. During cross, you can go all willy nilly with it. You can, you can say, you saw the barrel, right? And it was green, it was purple, and it was open, and somebody was like swimming in it. Again, you can say whatever you want. Like, it's, well, not whatever, but you know what I mean. Yeah. Very important. Very important. So many teams get into a spiral of screwing up here, and it really screws up your score, and it screws up the way you look to the jury and the judge and everybody who's watching your trial that day. Everybody's like, yes, they did not prepare at all.
If the witnesses, sorry, you mentioned the witness doesn't have to specify, like, if we're going back to the example, the witness can be like, oh, there was fuzzy material. Isn't under oath the witness obliged to say, yes, there was? Oh,
In what regard? Direct or cross-examination?
both.
I mean, if they ask, if they say there was a fuzzy material, and you say, what was that fuzzy material?
Then there's, okay.
Then they have to say it's
Yeah,
different.
okay.
But they don't have to say, if you say what was the material, they don't have to say go for it. They can still describe it and it's still not lying.
Okay.
Yeah. Why you have to be as specific, but also when you're doing direct as broad and specific, it's an oxymoron, but you have to be as broadly specific as you're possibly going to be. Yeah. So where was I there? Yeah, you just gotta you gotta really be on top of this and understand it. Expert testimony. All right. Every case has a couple people who could be classified as experts. And they're usually people who say, I have a PhD in microbiology from Stanford University or whatever. These are the hardest witnesses. They're the best witnesses for your case, but they're also the hardest witnesses to understand and how to question. First of all, first thing you have to do when you get an expert witness, these are usually witnesses that aren't directly involved in the case. They're usually the ones in the statements that are like, yeah, like I think that this is what happened, or like I don't know, like I was called upon this case to analyze these documents, or whatever. Those are experts. Sometimes you can classify people that are involved directly in the case. Like, for example, I don't know if any of you are doing the financial case. Anyone? No? Anybody online doing the financial case? No? Yes. Well, in the financial case, there's like a guy that worked for the bank, but he also has like a PhD in finance. In theory, you could try to get him admitted as an expert witness. The other side would probably argue conflict of interest. He's part of the case. He shouldn't be an expert. He shouldn't be able to give opinion on the fact of the matter. That's what the whole point of expert witnesses are, is they're the only witnesses, write this down, they're the only witnesses that can give opinion on the fact of the matter. So, put that more simply, if you have the defendant on the stand, or you just have some rando, like some lady who just is testifying because she saw something, she can't say, it is my personal opinion that this man committed this crime or whatever. Only the experts can say, it is my professional opinion that these documents are false, or that this thing is this. They are the only ones that can give opinions. And they can only give opinions on what they're experts in. So if you tender the expert as an expert in animal fur sampling, I'm going to use the goat fur thing for the rest of the day. If they're an expert in animal fur sampling, and you ask them, can you give an opinion on, whether the material of the barrel could sustain a gunshot? They can't testify to that. They don't know anything about the material of the barrel or whether or not it can go through a gunshot. Could you, in theory, ask them, can you tell me if the material of the barrel was strong enough to hold goat fur? they could probably testify on that because they have experience with gopher camera. And if somebody objects, then you'd argue that they'd say, well, how can you testify to the material of the barrel? And you'd say, well, he knows what gopher is. Like, he should be able to tell you if it holds enough. Anyway, you want to prepare these witnesses extra thoroughly because they're going to be asked questions that are more technical than other witnesses. So when you bring your witnesses and stuff, make sure that you are really walking them through, you know, they're going to ask you questions on this thing, and they're going to ask you questions on this. If they need specific statistics or whatever, a lot of times you're allowed to refer back to the affidavit. You can remind them, basically. You can say, can you refer to line 23 of your witness statement? Here you say that there were 300 milligrams of, this drug administered. And you can phrase your question however you want. But, yeah, please make sure they're prepared. And then also make sure that these people can communicate complex ideas. Like, no offense to anyone's witnesses, but like, put your smarter ones as the experts, please. Like, I don't know, just like, make sure that these people like can, if they're not really that into it, or I don't know, like it can really mess up the way that you're trying to communicate your ideas. And then make sure you're practicing with them. Before the trial, I would get with your witnesses and go through not only the questions that you're going to ask your own witnesses, but the potential questions that they may be asked by the other team. Some of the best ways of preparing for trial are to just think of the things that the other team is going to ask your witnesses, because that's what you have to defend. Like, the whole point of trial is that you're rebutting other people's ideas. Your own stuff, not as important.
Two questions.
Yeah.
First, like if we would think that the other expert is involved in the case, whatever, has a personal opinion, do we claim it before and then the judge can decide if he?
So the judge would say, are you the defense? You're the defense, right? So the judge would say the plaintiff can call their next witness. The plaintiff would stand up, say, we're calling this person to the stand. If you disagree with that, the judge will say, okay, are there any objections to this? And then you would say, objection.
And then you can decide if he thinks the.
And then you would, the judge, you would say, you'd only, when you do objection, we're going to talk about this in a minute, you only just say what the objection is, like one sentence, but you don't explain.
Yeah.
You just wait for the judge, and if the judge asks you to explain, you explain.
Yeah. But in
But
the end, the
sometimes the
judge can
judge
decide if the witness
is allowed or if it's not.
And also, because like we, from our defense side, we don't have experts in our witnesses. Like there's just one from the plaintiff side. So we have no.
How do you know? Who are your witnesses?
So we have the plaintiffs have the aviation expert,
Yep.
David Bowman, who's opinion, and ours are all involved in the case. So can we bring any own experts? Which
I think I could argue all three of those witnesses that are on this, that are in that list are
you can also
experts.
okay, but they are involved in the case.
Yeah, but it doesn't,
So
as
the
long
other
as they're
side,
not
no
giving
one's saying
opinion on the
anything
piece that they're involved in. So for example, they can testify to the procedure, like the agent can testify to the procedure of the ATF,
Yeah.
but he can't say, I think that I did things right. You know what I mean? He can't,
Okay.
then that would become.
But would you personally think that the judge would say, no, he's too involved in the case?
I think it
So like
depends
that-
on what the arguments of the other team are, because you get to admit your witnesses unless the other team has a very compelling argument against it, so. I would, if I were you guys, if they have any aspect of expert in it, I would try to get them tendered, and if it doesn't work, then don't.
Okay.
But it makes your questioning a lot
Yeah, that's.
more broad if you can tender them, right? But you have to lay foundation. You have to go, like the first 10 questions. Where'd you go to school? How do you do this?
Yeah, that's what I also wanted to ask, because always in
You're
the
all gonna
beginning you ask, okay, when did you start?
You're all gonna
working?
get- This week, you're all gonna get resumes for each of you.
Perfect, because we were already thinking, can we just say I'm married to
No,
a,
you're all
I
gonna
don't
get
know.
resumes of each witness. No, you'll get those sometime this week. I'm a bit behind. I know your scores are all supposed to come out. And then finally, closing statements. Like I said, I would think that this is the most important part. This is when, like, on TV shows and stuff, basically TV court is just one giant closing statement. Like, the things that they say and do in TV court shows are the only thing, you can only do them in closing statements. When they show diagrams, when they act things out or show a video or, whatever. Those are all during closing statements. You don't really show a diagram in testimony. You could, in theory, show, usually the only diagrams you show to witnesses are just like enlarged pictures of documents that you're presenting in evidence, right? But then like, if you have like your own thing that you've created, like a timeline or something, that's when you show it during closing statement, because there are no rules of evidence in closing statements. You can bring anything because everything's already been admitted into evidence that needs to be. As long as it's relevant to the evidence that's admitted, then you can basically say anything, do anything in closing statements. There are not very many objections that can be made.
So we have access to a TV or something and can connect.
Yeah, you'll have access to a PowerPoint presentation. You can also bring physical things if you want to. In real life, closing statements just by themselves can last 7 to 10 days. Like it's not like a speech. It's like a process. Like you say some things and you present things and you show videos and you like walk back through. You know what I mean? It's like they take a long time. The O.J. Simpson closing statements took 9 weeks, and so it's not like closing statements like my name is and this is what happened. It's like basically like closing arguments is probably a better way to put it, right? You're walking through. This is when you say. This is when you like go up to the jury and you say, "Do you think?" You know what I mean? It's like the more like showy, like theatrical piece of things. This is when you do your big like floor stomp and you say, "And that's why he did it, and this person did it, and I rest my case," and then you call it that. You know?
So we don't have any time limit on our call.
You do.
Yeah, that's what because nobody
You
always
do.
That's nice.
Each side gets more or less 85 minutes to present their entire case. About an hour per side. Gives you 3 hours, essentially, right? Do I think you should use all of it? No. You don't have that much to actually present, believe it or not. It looks like a lot, but you actually don't have that much to present. Your witness questioning does not have to be crazy long. You just need to get the points that you need to get across, right? Your opening statement should be short. Your closing statement should be the longest piece of whatever you got.
How long were the closing statements approximately?
And
About 10.
10 minutes. I mean, it depends. It's like the first round, it was like 5 minutes, and then the second round, it was like 15 to 20 minutes. It just depends on like how many things you're trying to argue. If you don't have a very good argument, you might want to limit your closing statements. You know what I mean? The more you talk yourself to death, it gets bad, right? So, yeah. All right, rules of evidence. Here's how you admit evidence. Evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence. That makes sense. So you can only admit evidence if it supports something that needs to be supported. If you don't need to admit like, and this was his elementary school report card. You know what I mean? Like that has nothing to do with anything. Unless, I don't know. I'm not going to go there. It's relevant evidence is admissible unless the Constitution or the rules of evidence say otherwise. This is when you look at that long document that I published, all the rule book basically, and it's all the different like very specific pieces. I can tell you right now, you don't need to know the whole thing, but the more you know in that rule book, the more you can crack down on your opposing team and make them look stupid. Because if you know the rule book and they don't, there's a lot of rules in that rule book, and I don't expect you to know all of them. But if you do know certain ones that you can use to jab at them, well, according to 1.1.2, like that's not allowed, and then they now look stupid because they have to go onto the thing and look at rule 1.1.2 and then make a rebuttal argument, and they're not prepared, and the judge is like, okay, you can exclude relevant evidence if its probative value is outweighed by a risk of unfair prejudice. I'm going to use a discrimination example. You cannot, even if it's technically evidentiary, you could not admit a document saying that this racial group is more likely to commit a crime than this racial group. Even if that supports your theories, that's causing a risk of unfair prejudice. It's causing discrimination risk. So then you can say, even if that supports your claim, That's a probative issue. It also, if it's confusing the issues or misleading the jury, like if you're just like introducing things just to like mess up with people's brains, which is a genuine strategy. Some people have no actual defense, and they're just like, we're just gonna like confuse the jury so much that they like don't even know what to think. Wasting time. This is a big one. You can object if people are wasting time. If you think that people are just, and this is not just for evidence, but testimony, if they start asking questions that are like clearly just trying to like run the clock, you can object for wasting time. And needlessly presenting cumulative evidence. If something's already been proven, if there's already a fact in the stipulated facts that have been agreed on and they're arguing that for some reason, you say this is already cumulative, like we've already decided this piece. Or if it's something in your mediation agreements, you already agreed to not talk about it, then you would say objection, this is needlessly present, this is irrelevant. Hearsay is another one. It's basically a statement not made by the declarant while testifying in the current trial. It's basically if you have Jimmy, who was the janitor at the supermarket, and he says, I was mopping the floors and I heard this lady on the other aisle say that Timmy was a murderer. That's hearsay. That's like, you're talking about 7 degrees away from you. You can't bring that to trial. Certain things, like present sense impressions, are allowed. In that moment, I thought this. This is what I was feeling at this moment. You could say that. Also, statement of then existing mental, emotional, or physical conditions. They can also testify to people that they saw. So a doctor could testify about their patient saying, I noticed he was sweating and shaking and, he was warm or whatever. That's, even though the person's not there testifying, the doctor can testify to what he observed. Yes.
What if they like technically testify for something that didn't happen? So let's say it was like in the supermarket and like, I don't know, Timmy's a witness. He testifies, he says, oh, like this woman was like terribly scared, but in the document she's not listed as like somebody who's present at the scene of the crime. Is that
That would be extrapolation.
Okay.
So we'll go to that objection soon. But yes, you can do that. Then there's the unavailability of declarant. This is Rule 804. You can look at this yourself, but it basically covers exceptions when the person that said this was unavailable. So in your witness statements, if it was an agent, the federal agent, saying that he spoke with another federal agent, if that person cannot testify at all, there are some rules to what can be said. For example, like I'm sure there's some testimony in the Qatar Airways case about the co-pilot. Obviously, the co-pilot won't be present for the trial, so there are certain rules to what can be said about the co-pilot and what can't be. It's basically rules against talking about other people when they're not there. And then expert testimony. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to that of their perception. So you can't say to the janitor at the supermarket, and what did you feel about, what do you think about the current, financial state of, Mercadona? You can't testify to that. He has no idea, right? But you could say, I don't know, if it was a financial thing, you could say, were the cashiers, what was your opinion on, like, what did the cashiers look like on the day of the crash? That you could say, well, they seemed pretty worried because they kept checking the cash registers and there was no cash in them or something. He can testify to that, but he can't testify. And he can't say, I think that they were worried because of the stock market crash. You can't say that because he doesn't know anything about finances or why they would be worried about that, right? Yeah. Expert can base their opinions on facts or data. Any of the documents in the case or you can have them read any documents if they're experts. Any document applies to the expert because they're supposedly experts as long as it's within their field of study or whatever. And objections. Basically, you all know what objections are, I presume. And you make them to stop things from being said in court or stop evidence from being entered. There's a few different types: hearsay, relevance, opinion, speculation, all this stuff. We'll go into each one in just a second. They have to be timely. So the second that it happens, you have to object. You can't it can't be talking for like 20 minutes and then you object on something that was said 20 minutes ago. Like it has to be right then. Otherwise it's not timely. And then you stand up, you say objection, stand up, or
You always stand up.
objection.
Oh, okay.
If you're objecting on a leading question and like they start asking the question, but the way they're starting is like it's leading, can you like object in the middle of the
Yeah,
question?
yeah, right when it happens.
Like,
Objection, yeah. You want to stop them from saying anything else, right? Because even if they say something, if the jury hears things, once it's said, it's been said, right? Like, you can say it's excluded all you want, but once it's been said, which is why sometimes attorneys will, and this is a lot more like court TV stuff, but it happens sometimes. Like attorneys will, they know that what they're about to say won't be admitted, but they just say it to like get the jury in the back. So you are a murderer, you know what I mean? And then they'd be like, objection argumentative, and it would be taken out, but then the jury's already heard.
And the judge always says like jury has to.
Yeah, and then the judge will say,
Forget about
you
it.
must
Yeah.
you cannot consider that in your
But they do.
like this, right? So yeah. And then usually the opposing party responds by clarifying, or they can say, we'll rephrase the question. If they don't want to argue it, they can just say, we'll rephrase. And that's usually fine. If there are multiple objections without ground, if you're just objecting to object, the judge may like sanction your village, basically like stop objecting on this ground. Like, you know what I mean? But that's, here are the types. There's hearsay, we've already talked about that. And relevance. We've already talked about hearsay and relevance. Those are the two biggest ones. Relevance is like the biggest one. Like, this is irrelevant. This doesn't have anything to do with the case. Want to go. Then there's opinion. As if the opinion is not being given correctly. The opinion is given on the fact of the whole. So you're saying this person is testifying to whether or not my client's liable and not to his own personal opinion, right? And then there's speculation. Witnesses can't be like, you can't really ask them like, how do you think my client was feeling on that day? And then they can't be like, well, I think he was probably upset. Like, unless they saw him, like, unless they physically saw him being upset, they can't speculate, right? Then we have character evidence. There's very limited aspects of what you can do for character evidence. If you don't know what character evidence is, it's basically evidence about this person saying that they like would or would not do something. My client wouldn't embezzle because he goes to a shelter and like feeds puppies on like the Saturdays. You know what I mean? And you can't really use that very much. You can use it in some certain circumstances. I encourage you to read the rules on this, but generally speaking, and character evidence also applies to corporations. Corporations are legal people, so all of these apply to the corporation as a whole, right? As a person. It basically says like you can't be like, well, my corporation donated $1 million to charity, so there's no way we could have, you know, put that dude through the meat grinder or something. And yeah, it just kind of like keeps you from. Yeah. And there's leading questions. Talk about leading. Yeah.
Sorry, one question. When you talk to a witness and ask them questions, often in the beginning, they're also try to figure out a bit about their character, whatever. Would it be also then be like that the other side can say no, objection, character evidence? Because I don't know, you want to prove that someone is integrated in society.
Well, that's the line here is character evidence can be offered to establish general ideas about the person, but if you're trying to use it to justify a specific action, you can't.
Okay.
So you can say, is it true that you volunteered on the weekends at the homeless shelter? And they can say yes, as long as that's just general. But if you're trying to point it towards, you volunteer on weekends at the homeless shelter, so therefore you can't commit tax fraud, like, then that's what you would have.
But you could say, yeah, because you're doing this and this with your company, what is pretty good. She tries to do
To
something
use the
with
US case for an example,
Yeah.
I maybe would, you can use it, for example, for the agent. If I don't know if this is even in the case packet, but you could say, like, I have documents here showing, you know, awards for your efforts in the past. You can use those because it's offering.
Could we bring this up? Because we would, like, they wouldn't be true.
What do you mean?
If we bring any certifications from their past, which
I mean, if they don't exist in the case packet, then they don't exist.
no, okay.
Esther?
Yeah, that's okay.
Yeah, I just wanted to say, like, I understand what you're saying, but what if it's like not the only justification, but if it directly, like, the character evidence relates directly to their actions, is that like okay? Because like obviously it's not the whole justification of why it happened or why they did something, but like it's not fully irrelevant. Like, okay, volunteering in a shelter and then doing a tax fraud, they're not really like.
Well, that's kind of the whole thing. It's admissible if it truly does justify certain things, but if it's not justifying certain things, then it's not admissible.
Okay, thanks.
But yeah, you're like if it's, for example, if you're in the university case and you're representing the university, you could use awards given to the university for diversity in the past or something like that as character evidence, but you couldn't use, I don't know, like if the dean of the school was like, I love this university, you can't really use that as character evidence for the university, right? Like that doesn't really help or add to anything. There are very specific rules. I would look at Federal Rules 404 for further clarification. Then there's compound questions. You can't ask 5 questions in one. You can't say, what was the color of your car and why did it have windshield wipers and what were the make of the tires? And you have to break that up, right? Very simple. And then this is mock trial exclusive. It doesn't exist in real life. But unfair extrapolation is an objection that you make if the witness starts making things up that aren't in the case, that aren't in their story. So if you have a witness who worked in an oil company, it says it in the case packet, and they say, you work at an oil company, and they say, no. Then that's unfair extrapolation, right? It changes the whole thing. However, witnesses are allowed to make things up that don't materially alter the facts of the case. So you could say, if it doesn't truly mess with the case, you could say, did you like working at the oil company? And if it doesn't really mess with it, they could say, not really. Or they could say, I do, or, whatever. Or like, what do you usually wear to work? The oil company. I don't know why you'd ask that, but they could say, I like, I wear a green shirt and some, jeans. As long as it's not messing with the case, then they can say that. And that's usually helpful for like, I like to say that you can extrapolate on the facts. Like, for example, if you have a testimony that says, I was, I came home and she was dead on the floor and I started crying, right? And that's all that it says. The witness could extrapolate when you ask about it and say, yes, I came home and walked in and I mean, there was, the pill bottle was there and, they were laying on the floor and I just didn't, they could start inferencing using the facts of the case to make their story more realistic. But like I said, they can't come in and be like, I walked in and he was doing an Irish jig and he was like wide awake and like, then that screws up the case, right? Because the guy's supposed to be dead. So extrapolation, big one. Because it could really, if you don't call their bluff, if they start making things up and it changes the case, then you're really screwed, right? There's some other things. Ambiguous or confusing questions. If the question's like doesn't make any sense. Argumentative. This is like something where you're like, so you are a murderer. That's argumentative. Like you're accusing them of something, basically. You can't accuse people of anything necessarily. You can hint at it, but you can't just outright be like, you are an embezzler. Asked and answered. If they're continuing to ask questions that have already been answered, this also applies for facts that have already been established. You have a list of things that you've already agreed on. They start saying, this happened, and it's already been agreed on. Asked and answered. Can we get over this? And then lack of foundation is if they didn't properly lay the grounds for the witness or lay the grounds for the piece of evidence. You can say objection, lack of foundation, and that piece of evidence or that witness may be excluded. The judge, you already know what the judge does. It's procedural. In a bench trial, he makes the decisions. And this is including interpreting and applying laws. The judge is also in both bench and jury trials. The judge is the one that decides the compensation. The jury recommends compensation, but the judge decides compensation. So And then attorneys, obviously you represent the interests of your clients and you advocate for their position and, choose it. Bench trials, the judge serves as both the judge and the jury, makes a decision on the law and the facts. You're really adopting more of a straightforward, like law-focused approach if you're in a bench trial. You're arguing case precedent and not really as much trying to tell a story because the judge is already a legal expert and does not need to hear. You don't have to explain, like, according to the laws of California, he already knows, right? You just say, Rule 404 says this. Or you don't even have to say says this. Just say, we want to exclude this under Rule 404, and the judge will. I don't think are any of you doing a bench trial? And then there's admin trials. This is basically when you get to the appeals level, and this is when you're proceedings before a government agency. This especially applies for the guitar case. You would go to an administrative trial for entry ban. Yes, that's sir.
Yeah, so I just wanted to say, like, if we're not getting to the point yet with to the administrative trials, so do we not bring up at the ban at all because it is an administrative
No,
proceeding?
you do have to bring it up because the judge has to order you to go to administrative court.
Okay, thank you.
Wait, so we will have multiple trials?
No, you wouldn't actually go to
We
administrative
just
court.
don't.
I would basically, if you get that order, if you succeed in that, then I will, in your judgment,
Okay.
tell you what the administrative court decided. Because those cases usually last about an hour, like they're very, very fast. But they're not real judges. They're just like attorneys that work for that agency, and they sit in like a hearing and they decide on it. Like immigration court is not a real judge. Like immigration judges are classified differently as a federal judge. At the end of the trial, an entry of judgment is made. They're in writing, they're clear and concise, and they basically say, here's who wins and here's what the relief is. And it's entered immediately upon verdict or the decision. And then you'll be notified. I mean, we're going to read it in open court. We're going to tell you while you're standing there what the decision is. The successful party, this is you don't actually do this, but this is how you collect if you and there's appeals. So the losing party, what we would call the appellant, believes that the trial judge made a mistake in interpreting the law, or you can argue that the judge abused their discretion in procedural rulings. For example, if you think that an objection, like if somebody objects to a piece of evidence and it gets excluded, if you think that that was like procedurally incorrect and you think that that really altered, you could claim that. Or you can say that the evidence presented at trial was insufficient to even render a verdict and that this verdict should be overturned. Usually, you're going to be arguing, number one, that there was a mistake in the interpretation of the law. But you could also argue to it. You file a notice of appeal. They both submit, both you and then the person that you're appealing against submit briefs. And then the circuits hold oral arguments where they present their positions and answer questions. Case law. Citations provide the basis for your arguments. Obviously, you want to show precedent and support for what you're trying to argue. When would you use case law in a trial? You could do it in opening and closing statements. You could do it in response to objections. That's the big one in trial. In this case, this objection was not sustained or whatever. You can ask witnesses about legal standards, but only if they're experts. It's kind of inappropriate for like lay witnesses, which are witnesses who are not experts, to interpret or like read legal texts. Like, can you read what this statute says? They don't. They're not lawyers, so they don't know. But if it's like a police officer, maybe you could finesse it. And this is how you cite case law. Kind of important if you do it in your written arguments and stuff, because we check all of your citations for accuracy. So, couple of things, couple of tips. You're not allowed to use ChatGPT to write your arguments, right? But I do think that you should utilize it in certain cases. Couple things. One, you can put the case into ChatGPT and it'll put it into the citation format for you. long as you put the like information. And then number two, this has been very helpful. If you need, make sure that your questions aren't leading. Put the questions you want to ask, and then say turn these into non-leading questions. That's a very good tool, right? That's fine. As long as you're the one doing the actual writing and it's just reformatting, I don't care if you use it. But if it's very obviously ChatGPT that wrote your entire brief, then we're gonna throw it out. All right, let's do some case studies and then we're done. Yeah. What we're gonna do is,
Sorry, if we have questions now, should we ask them now?
yeah, let me take questions right now if you have any questions about the basic stuff. Anyone?
When does the appeals work be if we do reach that level?
Everybody does reach that level. And that is
What?
the appeals. I remember when that was. Oh, also the final round is November. Is it Pedagogika? And you're excused from class that whole day.
Is it November?
November 13th. Monday. You have an IE granted absence. It won't count against your 80%, and you'll spend the day at Pedagogika. The Pedagogika law firm I'm past the I'm straight right now.
And what are we gonna do in general?
Oh, I have another question. Do we have,
What are we gonna do in the final round?
Huh?
Exactly what we're gonna do there.
Final round is the Supreme Court.
But if we have to go to the Supreme Court.
Yeah, and
Or
then
everyone.
you can also, I mean, we have a cocktail reception afterwards there.
Yeah.
So it's like the awards and stuff, so you
Okay.
can come and watch and
But not every case, maybe.
not every case will make it to
Okay,
the Supreme
that's fine.
Court. But I would, it's, you still get your certificates and everything, so. More
what we
questions?
get a fee for the trial?
It would be before the trial day, before your trial day. We'll send out a link on Friday. And it's 15 years per non-member.
What?
There's a fee, so that way we can pay for everything. We're having to rent, pay for cocktails and stuff, so like it's, yeah.
If we are filing like a countersuit, how does that work?
Yeah, did you see the response template in the thing? There should be a section about countersuits.
Okay, but do we actually follow up on those?
Yeah, I mean, if you file a defamation countersuit,
Okay.
then, or something, then we'll consider that in our
Okay.
thing. But then keep in mind that now adds an element that you have
Right now,
to
everyone's just.
actively like pursue, right?
Is there
Okay.
some way we can the order you saw? When
Sorry, one last question.
Circuit Court is the 4th and the 5th of November. The appellate court, yeah.
And also, I don't know if we're allowed to do it. Maybe it's anywhere written and I didn't see it until now. But sometimes the lawyers or whatever, they ask for a short break or something.
Mhm.
Is
A
it?
recess.
Yeah, like we're also allowed to do this.
Yeah, and
And then the
the
judge
judges
decides. Yes.
will also have their own, like,
Yeah.
if you need a recess or whatever, that's fine. And there's usually one between direct and cross examinations
Yeah.
and some of that stuff.
But the judge could also say no.
But the judge can deny it, yeah. You just stand up, Your Honor, can we have a recess for 10 minutes or whatever, and
Yeah.
they would decide it. Any more? Yeah.
attorneys do you have per, because you obviously have 3 witnesses per group. How many attorneys do you have?
Per group?
Yeah.
4 to 6.
Okay, oh, okay.
There are 16 teams with 4 to 6 attorneys each. So, 8 cases, 2 trials per like pattern, basically. Any more questions for right now?
I have a question, like every single person from the group has to be present for the final day?
No.
And what's gonna happen if someone doesn't come? Just because someone from my group just
Like I
asked
said,
me.
you just have to have at least the 4 members present.
Okay, thank you.
And if you're not in the final, like if you don't make it to the actual final round, the championship, you don't have to be at first your time. But I mean, you're like, I don't know, like it's drinks and a certificate, whatever. I don't know. If you're gonna go through this whole thing and then not go to the like championship, like I don't know what you're doing, but okay. Yeah. Right. Okay, we'll do the case studies. So, you do breakout rooms in here. I was gonna like kind of split you into groups and like do like an actual like exercise, but I don't know. I don't know how Google Meet really works in this regard, but we'll see.
Are you gonna put these slides?
Yeah.
Yes, you will get a copy of this.
Thank you.
Can you do it? I don't think you can actually.
What?
But breakout groups.
I think it's the. It's no, it's Google.
I have like
I just know it.
yeah. Google Meet's a little behind. Okay. Well, those of you online, if you're with your teams, maybe I don't know, like give each other a WhatsApp call or something. I'm gonna show you a case study, and I'm gonna do like. Are you on their team?
Yeah.
Okay, so you come down here, and then you just join them for this exercise. Right? And then you you guys combine forces.
Yeah.
So it's 5 of you and 4 of you. Okay. All right, here is the facts. I'll jot down some notes, but you might want to, just because there are multiple slides for this, so you might want to just jot down a couple of quick briefs. It's very chill, but there's this plaintiff, Alex Smith, and the plaintiff is claiming damages due to a defective medical device implanted in them, alleging that the device caused very bad health complications. The defendant, Johnson Medical Devices, denies the claim, asserting that their product meets all industry standards and regulations. Here's what you're going to do. You have an expert witness, and what you're going to be doing is you're going to be working in group to craft a sequence of about 7 to 10 questions designed to lay foundation for their expert testimony. Okay? You're trying to make this person an expert. Here's the person, Dr. Taylor Martinez, okay? A PhD in biomedical engineering from MIT. They have 20 years of experience in designing and evaluating medical devices. They've published 50 peer-reviewed articles on medical device safety. They are a former FDA consultant on medical device regulation, and they're a current professor of Stanford University teaching courses on medical device design and safety. So that's the resume. Maybe snap a picture, just so you can
Just need that.
reference it. And then Dr. Martinez is going to testify about the design flaws in the medical device in question, providing expert opinion on how these flaws could lead to the health complications experienced by the plaintiff. Here are your instructions. Number 1, establish Dr. Martinez's background, experience, publications, and positions. Link Dr. Martinez's expertise specifically to the type of medical device in question, and then identify methods, data, or research they might use to form an opinion on this case. What you're going to do is you're going to lay about 7 to 10 questions to lay the foundation. You're just doing the part that you're trying to get them admitted as an expert witness. You're not actually asking them questions about the medical device. You're asking them questions to lay their foundation. Am I clear about that?
And you are Dr. Martinez.
I will be Dr. Martinez, and you will question me. And then what I'm going to do is the other team and me, while you're asking me these questions, I'm a direct exam, so no leading. I encourage the other teams to object on questions that would be deemed inadmissible. Okay? I'm going to give you 8 minutes to do this. Okay? Until 16:25.
Can they be like compound questions, like where did you attend school and what is your degree? Or is that 2 questions?
No, you got to do it in 10 questions. You got to lay foundation. Enough. I'm going to go back. Do you want me? Would it be more helpful for this slide or this slide to be displayed?
That one.
This one?
Yeah, but also one time, maybe the objections again that we.
Yeah.
Because I don't know everything.
No.
I can write it down.
Is it gonna go all of them? I only have starting.
Yes.
No, wait, that's the first.
Das ist einmal die Befragung.
But the first one, no.
Das ist Frage gestellt und die dann keine.
This one?
Okay, should we ask like where did your degree?
Okay, so the key part of this is deciding what questions are more relevant to lay foundation. Like sometimes, like obviously you want to ask their name. We're gonna assume that you already asked their name.
Okay, that makes it.
But you like maybe you don't need to include every single one of these things, right? You just want to do the things that answer these 3 points here.
Yes. Where did you obtain your degree? No, what's your name? What did you obtain? Wait, name is already said. No, you have to ask him.
No,
No, he just said it's already said.
Wait, so name is included in our 10, yes?
I think you already said that the name will.
Name included in our
It
10.
will be already said, right? Like that's not relevant.
It's included in our first question. Or it's in, we don't have to include what's your
The
name.
name is already said.
Yeah.
It's already said.
Everyone
Okay. Good lord.
So I mean, we need education.
They're in the back. Yeah, okay, so we'll start around.
I will. On your path, your job, well, somebody is finding. No.
I know.
For a record, so.
Should we maybe sit the competition up there?
Oh, sorry.
What's that? So you went on medical. Okay, first, we just say poetry and cover as much as possible. So not study side, not ask what you can find. Yeah. Only got like a record of yours. Yeah. That's also what or maybe your parents. About the.
I said, can you tell me about
Beginning from
yours question was good, and then I took it and I wrote, where can you tell me about your path from university to your current occupational position?
Okay. Yeah, I think that would be the second option, actually.
It's like, it's from
From
university.
university to your current occupation.
I would try to understand which includes education.
So.
So from university to your current occupational position.
Okay, yeah, I'm getting it really into it.
Okay,
I mean, it's the high school.
okay.
Applications. Okay, then she needs to tell us where did she specify in her job that we know that she has the experience in designing and evaluating medical devices.
And you have a detail.
And so how did she?
Can you detail your experience in research?
No. She has to answer. We don't know. She has to
No,
answer
we're asking.
where she's specified in whatever.
Yeah, can you detail your research and your publication?
That's what you go in the.
What price?
Yes,
But we don't know
PhD.
this medical thing. She has to mention it.
Because
We can just ask her what's in the. No, in this case, I can ask her
Your occupational position, in her current occupational position is, what is it?
Okay, let's go step by step. She will mention the PhD.
So it's like, hey,
Yes, then you're.
Then we will ask,
So what's your?
then we have to ask company that she tells us that she has 20 years experience in designing and evaluating medical devices. This,
Can you detail your experience in medical device design and safety?
Can you outline?
Because
like,
we
we
already
already
question
assumed that she had.
to your current occupational position. I feel it gets us to the point of like where her current job is, and then we'll introduce medical device.
what degree did
Yeah.
you?
And how did you gain?
What did you like, what was your educational work? What are you doing right now?
Outline your educational.
Your-
Yeah. A lot more. So we're saying. What exactly are you doing in your current position?
So, but we already also have to go to the question that she.
It's a different if I work in a kindergarten and then you actually say. It's important to see if I'm a good kindergarten person.
Maybe also she has mentioned like these clients, whatever she worked for.
Okay, what if they use most influential,
Within the.
Yeah, cases, whatever like this.
You already
And
said-
also we have to mention that she published the peer review.
What's your video?
That she has, that she proves, like, to prove her experts that she tells us that she has the articles, whatever.
Yeah, so what has been your experience in research fellowship?
That's not.
What's called?
If you have any practical.
I guess that could be.
Right.
Yeah,
I know, well,
Yeah.
That could be.
Yeah, we also has question about the research materials.
The articles.
So detail your experience in research with medical. And then.
No, but this is the 20 years of experience that then that she published with peer reviewed articles on medical learning.
Yeah.
Maybe also,
Yeah, but any practical experiences.
Would you?
For example, no. I started with the education.
Have you had any publications to the peer review?
yes, we close.
Would you explain your contributions to peer reviewed?
Courses.
Yeah, explain the contribution.
About the medical device
Peer
design and
reviewed
safety courses that you teach.
research
Experience
or
in that
peer
field.
reviewed papers? What does it say on that?
I don't know.
Peer reviewed articles on medical device safety.
Because we asked about documentation. We say that this, and then it's what you mentioned.
The articles were on medical device safety.
That should be the last question. No, that's the second to last question.
Not be leading.
She has to mention it, they have to get a question where she will answer it.
Or you can ask, or you can ask
If we ask that,
If you ask the question, if you ask the question, can you detail or can you explain your path in university, your current occupational career? That's going to introduce the fact that she works on medical design, research, and safety. So those questions would then be relevant because she's already introduced that from that question.
Or, yeah, and then okay, so look at how these courses.
How many years of experience? How many field?
This has been. Divide all the concerns. We can't say that she's already mentioned it in this previous question when we asked, what's your path to university?
okay, so now there are two things, that's the first one.
All right, 3 minutes.
Yeah, right? Link of your market's expertise specifically to the medical device question and the associated.
There is also,
So we should have about.
education expertise.
Something about and if he teaches his procedures.
This is the case of this guy. We have to prove that
I can't read this.
we have to prove that she is an expert in the claims of the guy.
Okay.
Have you worked on cases involving health complications from medical devices?
Perhaps it's not only if you present, she says, yes, we have to share some.
What is your experience?
What is your experience?
Similar cases in.
Because what I want to, what I was thinking is that we could do something like.
What else?
Wait, I can't, you gotta give me one question at a
So do
time.
you have any experience?
Instead of have you had.
With,
Did you ever work for a government agency?
medical.
I think we should go on to the. So,
So what's your experience dealing with cases? What is your experience dealing with cases, where medical devices have resulted in patient harm?
What is your history?
What is the history? Doesn't matter.
Then important she now gives her personal opinion on this case, because then,
But aren't we just establishing her as a witness right now?
but then it's identify the methods, data, research, or other information obtained used to form their opinion on this case.
Okay, okay.
Can you tell me about your?
Yeah, tell me about your evaluation. Yeah. About.
Yeah.
What we need is
About your
it goes about the meets all industry.
Personnel, she has her opinion.
Then I was
And after she has her opinion, what method?
Well, we're not asking about her opinion right now. Just tell us about your opinions. How many questions?
But if we have to identify after her, what her methods, whatever, which she used to get to his opinion, she's
Would you ask about the slides? We're not allowed to ask you questions right now.
I'm not an expert yet.
Well, no. But ask him a question about this. Like, okay, do we have to establish that she has an opinion on this case? Like, do we say, like, can you tell us your opinion on this case? Or do we just say, like, what methods did you use in establishing your opinion on this case?
So we get to like to.
I think that's pretty good.
Okay.
I got experience on like heart.
Which,
I don't know if it's about heart.
all right,
No, you can say just.
Yeah,
do you have any?
all right, time.
Okay, next, when she told the opinion.
Okay,
I got
considering that Gustav and Maxime both participated last year, I'm making them go first. Making your team go first. I am Dr. Martinez. On the stand. Also, those of you online, did you like do it or are you not doing it? Did I see that?
Yeah.
That should give you your answer.
Sorry.
You want it?
You should answer.
What do you mean?
Your question.
Oh, yeah. Yeah, sure.
Oh, that was me.
Okay.
No.
We have 2 more minutes.
No, it's
No.
fine, bro.
Okay. My name's already been stated for the record. Oh shit. Hold on. Wait. Whoops. Okay.
So the other team can object, right?
Yeah.
Not gonna object to you. Can you state your occupation?
Yes, I am a biomedical engineer, and I work for Johnson Medical Devices.
You outline your educational background.
Yes, I have 20 years of experience. Most of that as a professorship at Stanford University. Teach courses on medical device design and safety. I've also published a few.
What courses did you teach at Stanford?
I teach specifically on medical device design and safety as a 6,000 level course.
Do you have any practical experience in this field, in the field of biomedical engineering?
Yeah, I'm a former FDA consultant, and
Do you have any publications regarding your field of expertise or like publications?
Sure. Yeah, I published about 50 articles.
And where did you, okay, actually, no, we already specified the FDA. Did you have the opportunity to familiarize yourself with the device in question? Or in this case?
Yeah, I've looked into some of the line flaws. And then now you ask the judge to tender me, right? So what are you tendering me in?
Would like to qualify this witness as an expert in the field of
Biomedical
medical
engineering.
device. No, wait, medical device design and biomedical engineering.
Okay. Pretty well done. Yeah. Except for I would object as part of the opposing team. I would say that there was not enough foundation on a general biomedical engineering certification. I would have gone further into, because you focused a lot on the medical device design, even if that wasn't your intention, that's what the witness was saying, right? So you obviously want to like expand the biomedical realm if you want that classification, which I'd always advise to go for a broader classification because then they can talk about more things.
Okay.
Because if you say medical device, sure that's what they're going to talk about, but then they're really looking for what they can.
So we should go more into what, like what type of.
Yeah, I would honestly like. I would even like. I'll say my opinions after I hear there. All right, well done.
Can I just stay?
Yeah, you can say that.
Okay. Can you tell me about your path from university to your current occupational position?
Sure. I got a PhD from MIT, and then I became a professor at Stanford, teaching some medical courses here and there.
Can you specify your certifications?
Yeah, I have a PhD in biomedical engineering, and I am an FDA consultant. So, and I also have a professorship at Stanford.
Can you detail your experience in research with medical device design, safety, and biomedical engineering?
Sure. I've designed and evaluated many of these devices, but then I've also published some peer review articles on safety and efficacy.
Can you go deeper into your contributions to these peer-reviewed articles?
Yeah. They are specifically on safety and efficacy of medical devices, and I've also focused a lot on regulation and compliance when I worked with the FDA.
And in your practical work experience in this field, what contributions specifically did you make?
What contributions did I make in the FDA? Again, regulation, compliance. I don't know. I did a lot of evaluation. I did a lot of work with safety and whatnot.
And
So I would have objected there as counsel. I would have said asked and answered.
what is your experience with cases where a medical device has resulted in patient harm?
My experience. Can you repeat the question?
What is your experience in cases where a medical device has resulted in patient harm?
Well, I have, like I said, worked for the FDA, doing regulation. I have studied a little bit about health complications, but I haven't really worked directly with patient specifically and whether it was harming them.
Can you explain your methods of evaluation for the medical device in this case?
Yes, I use peer-reviewed articles as well as holistic studies, including their device design and safety, and scientific standards to ensure that my research is correct.
Oh, the judge.
That he's
I'm
our
judge also.
expert now.
The judge. Is our witness?
You would say I'd like to tender our witness as an expert in.
I'd like to tender our witness as an expert in medical design, safety, and biomedical engineering.
I would. Yeah, I'd probably grant that. The only thing I'd say is that, what was that one question about the patient harm? Can you repeat that one more time?
Have you, or what's your experience in cases where medical devices resulted in patient harm?
So that would be leading. I would rephrase that slightly to say, do you have experience
Okay.
with patient harm?
I know.
Instead of what is your experience? You're suggesting that they already have experience, right? So, yeah. Those of you online, do you have anything for me, or are you just observing? Okay. Yeah.
This would be an objection for speculation, or
That'd be an objection for, probably take it a couple ways. I would say objection leading. That would be a leading question. Or, yeah, because speculation would be like, do you think that the medical device is a cause harm? You maybe could. They're not an expert yet. They can make that speculation if they are an expert, but if you ask them before they're an expert, then that's speculation. All right, last thing that we're going to do together, and we're done. Here's a list of questions. We're going to go through them, and we're going to decide whether they are objectionable or not objectionable. Okay, take a vote.
That's for a
On
direct.
the rep?
This is leading will not be an leading is not an objection here.
Okay.
We'll just consider that they are on cross-exam. Okay. All right. Isn't it true that you felt remorse after selling the defective device to the plaintiff?
And leading.
Yeah, but
Because there's an example that
Hold on. So let me just get. How
What
do
are
you
we doing
rate-
here?
Deciding. First of all, let's raise your hand if you think that this is can be objected to. This first question. Raise your hand if you don't think it can be objected to. You don't think it can. For number one.
is cross, so you can.
Okay. So what would be the if you could object to it? What would be the foundation for an objection? I'm going to newsflash. This is objectionable. Number one, you can object to it. Why would you object to this?
Speculation. Opinion.
Hmm?
Opinion.
No, because you can testify to your own feelings.
Oh.
Where he is basically assuming that he felt remorse.
Yes, I would. So that's part. There are two pieces to this. I would say that this is facts not established. So saying that the defective device, like that's something that's the reason you're in court probably for this, right? So that would be facts not established because you're saying that the device is defective when that hasn't been established yet, right? But then there's also another aspect.
But how would you call it then? Objectionable? Lack of foundation?
Facts not in evidence.
Wait,
Facts not in evidence.
okay, so this is evidence.
Yeah, they're talking about an defective device. So unless it's been established already that the device was defective, then no. That's why this one was harder because you don't really know, right? But there's also another part of this. It's not speculation, but it's similar.
Leading question, but we can't.
No, because you're on cross. These are all on cross examinations. You're allowed to lead.
Oh,
That's
this is
right. Yeah. This would be argumentative, and let me tell you why. Because you're accusing the person of selling a defective device. You're saying, is it true you felt remorse after selling a defective device? So there's two accusations here. One, that you feel bad because you're selling an illegal product. It assumes basically that they knew that they were selling a defective product. It's a bit low key on the argumentative side, but there is grounds for argumentative here. Number two, can you describe the process you used to determine that the device was flawed?
Good foundation and
Well, first of all, raise your hand if you think you can object.
it depends on what's been said, but like if nothing else has been said, then yeah.
Okay, well, you're questioning a witness that clearly has determined the device was flawed.
Oh, they have.
They
so,
personally
like,
have. So you're questioning this
okay,
witness.
then-
Is this question, can you object? Yes or no? Thumbs up or down? Correct. You cannot object to this question. This question is seeking to elicit factual testimony about actions and methodology without assuming facts. So, yeah. If you said, can you describe the process? How would I use this to be argumentative? Like if you said, can you describe the process used to determine that, like, Mr. Johnson hates children or something like that, then that would be a little bit like us, right? Because you're accusing the guy of whatever. Number three, you would agree with me that the device is completely useless and dangerous, correct? You think yes?
That you can object, yeah.
Yeah, it's argumentative. There's also another piece.
Is it also opinion?
Could be,
You could say something.
depending on if it's an expert or not. But there's also another piece kind of hidden.
Could it be a compound question?
There you go. Because you're asking about useless and dangerous. You're asking about two different things, two very different concepts. Yeah. Number 4, please state your name and occupation for the record.
Is it also compound?
The thing is if you objected in on this, considering it's a very, very common thing, you'd just be seen as doing like kind of a bit of a frivolous objection, and that likely would not be. You could,
But normally,
everybody's gonna be like,
yeah.
bro.
But theoretically, it would be.
It should be
common.
But I would say no, not objectionable. This is a very common question to ask. Name and occupation, get us out of the way, right? Number 5. Didn't you tell my assistant yesterday that you regretted your involvement with Johnson Medical Devices? Why? Here's that. Question seeks to admit an out-of-court statement for the truth of the matter is certain. So you're saying the assistant's not here to confirm or deny whether that was said. So.
Don't you ask the person who said it? Is the one who said it.
Yeah, but you still would have to have the. Didn't you tell my assistant yesterday that you regretted your involvement with Johnson Medical Devices? Hearsay that asserts to fact of the matter, which is involvement with Johnson Medical Devices, would be you'd have to have the witness come in and confirm that in order for that to be.
The other person.
The assistant would have to confirm it. And if you don't have the assistant with you, then. In your expert opinion, is it possible for the device in question to malfunction in the way described by the plaintiff? Yes or no? You object. Nope. Assuming the witness is qualified as an expert, it seeks their opinion on the matter as their area of expertise. And then last but not least, you're just trying to defend the device because your company profits from it, right? You're basically implicitly accusing the witness of bias without establishing any factual basis.
Can I ask something? What's the difference between leading and argumentative? Because in both cases, you're suggesting the answer in the question.
In a leading is more about the technicality of suggesting the answer. It's the way that it's phrased. Argumentative is more of an accusation.
Okay.
That's the difference between suggestion and accusation. If you're saying you're just trying to defend the device because your company profits from it, you're saying you're accusing them of doing this. If you say your company profits from this device, correct? That's leading. You're leading a question because it's suggesting that they do, but you're not necessarily accusing them of any wrongdoing. Like profiting from a device is not wrong. But in theory, this is wrong because you're defending them only because you make profit, and that would be racketeering. So, there are very fine lines for every single one, and every time, sometimes the objection is just, and a lot of times, like the judge will allow questions or answers that help move the trial forward. So sometimes, even if it is leading on a direct exam, as long as it's not like causing major issues, sometimes the judge will just say, "I'll allow it," but tell the counsel make sure that you're watching the leading questions. Like I wouldn't object to leading questions unless it's something that you don't want to do. If it's your name is Jim, right? Like yeah, it's leading and you shouldn't be saying that, but like who cares? Actually, everybody knows his name is Jim, right? There's the answers. That's it.
I have a question on is there an objection for when a witness starts going into storytelling?
Narrative.
Narrative.
Yeah. You can, in theory, object for just about anything on earth. There's not a word for every single thing, but if you think that a witness is behaving or an attorney is behaving incorrectly, sometimes you don't have to say the name of you don't have to say objection argumentative. You can just say objection, Your Honor. They're clearly trying to cause problems or whatever. But yeah, sometimes the judge will say, okay, but what objection are you actually giving? And you need to have an answer for that. Any additional questions before we end off for today? I appreciate you guys coming. Hopefully it was helpful. I'll share with you this PowerPoint and get you your scores sometime today.
Send us the like other information about all witnesses?
The resume?
Yeah.
Yes. We'll try to do it by Monday. Okay.
Thank you so much.
Bye, guys.
Yo, I